Hello, folks. Welcome back to World War II TV. And this is the second in our double bill of war crime specials today. Michael Bryant is a professor of history and legal studies and comes to the channel with a thorough understanding of the Nazi war crime process. He will explain the legal framework of the Nuremberg trials. I'm delighted to have our proper first legal expert as opposed to our kind of more military history expert. So good afternoon, Michael. How are you today?
Doing great. Thank you, Paul. I really appreciate you having me on today.
Thank you. So, as we're beginning to find with this series, the breadth, depth, and sheer number of crimes perpetrated by the Nazis were on a scale that the world just hadn't seen before. How on earth, and then we'll discuss this as we go with the presentation, did the four Allied powers set about planning the trials? I mean, you'll go into detail later on, but I mean, it must have been a real kind of head-scratching moment of, where do you start?
Well, there is no straight path to the trials, as you know. It's a snaking, tortuous path that involved a lot of early commitments to an idea of actually summary execution without the benefit of a trial. So today I would like to talk about how it is that the legal framework of Nuremberg evolved and was ultimately implemented then at Nuremberg at the trial of the major war criminals in 1945. And I'll wrap up just talking very briefly about the so-called subsequent trials, which the Americans held in Nuremberg, 12 subsequent trials to the IMT between 1946 and 1949. So I'd like to begin today by just pointing out something that is really striking to me in my study of this topic. It has been so for years, which is that this topic, this subject of Nuremberg and the post-war trials held, especially by the Allies, might not have happened. Right? And there's a series of ironies, I think, that creep into this history that are noteworthy. And one of the first ironies that I wanted to talk about in this history is it involves this guy, whom everybody readily recognizes. That, of course, is Winston Churchill, the Prime Minister of Great Britain. Once reports of the kinds of atrocities that the Nazis were carrying out in occupied Europe began to seep out of Eastern Europe and made their way back into London, where so many of the exiled governments were. And of course, where the British government was and British intelligence was gathering information on what the Germans were doing in Eastern Europe. Once these stories of atrocities, mass shootings, the mistreatment of combatants, and also of non-combatants, the story of the first death camp at Helmno made its way back to the West already in the summer and fall of 1942, so pretty early on. And Churchill resolved that the best way to deal with the top Nazis, so the Nazi leadership in essence, was not to give them their day in court, but to have them declared to be outlaws. This is an old medieval idea that Churchill goes back to, along with his main legal advisor, Sir John Simon. I think Simon is the one who came up with the idea, or at least espoused the idea, that the major war criminals could be declared by the outlaws to be by the major victorious powers after the war would declare the major war criminals to be outlaws. What this effectively meant then, just as it did during the Middle Ages, was that anyone who encountered the outlaw would be justified in putting that person to death then, without the benefit of the trial. And this was the dominant approach that Churchill and Lord John Simon adhered to for the next couple of years, really up until the time of the San Francisco Conference in May of 1945. Not until then did they alter their thinking about what they wanted to do with the major war criminals. They wanted to line them up against a wall and shoot them. Now, there might have been trials by military commissions or maybe by the indigenous courts of the countries overrun by the Nazis of other war criminals, the lower ranking people. But when it came to the top leadership, that was what Churchill desired. And insofar as we can tell, at least for a time, Franklin Roosevelt subscribed to this as well. But yet again, we run into another irony in this history, which is so striking for me, namely that it was Stalin and the Soviets. I think you'll have a later program on the
Yep.
Soviet trials, but maybe I can give a foreshadowing of that to a certain extent today. It was really Stalin and his government that, ironically, insisted on trials and actually told Churchill that the Soviet Union would not accept the idea of summary execution. And but for Stalin and his advocacy of holding some kind of international proceeding for the major war criminals, Churchill, in his view, may have prevailed. Certainly, Franklin Roosevelt was leaning in that direction. So there was a conference between Churchill and Stalin in October of 1944, where Churchill wanted to float this idea with Stalin that the major war criminals be executed. Stalin dug in his heels and said, absolutely not. The Soviets would not agree to that. And this ultimately, of course, would carry the day. Now, as I mentioned before, Franklin Roosevelt himself agreed with Churchill. There was a lot of back and forth about this. And one of the prominent members of Roosevelt's administration was this guy. This is Hans Morgenthau. He was the Secretary of the Treasury. Now, you would think that a Secretary of the Treasury would not be involved in crafting war crimes policy. But again, if that was your expectation, it was not founded in this case, because he was directly and intimately involved in influencing Franklin Roosevelt's approach to the major war criminals. In particular, Morgenthau was of the view that that the Nazis could be divided into two types, two categories: the type 1 and the type 2 war criminals. The type 2 war criminals were the lower-ranking people. These individuals could be dealt with through military commission trials, or being sent back to the places where they had committed their atrocities for trial by the domestic courts of that country. And I'll talk about the Moscow Declaration here in a moment, which set forth that policy. But when it came to the type 1 category of war criminals, these were the major war criminals, the policymakers, the heads of the military, the heads of the SS, the heads of the Reich Security Main Office, and of course Hitler and his entourage. These are the people who implemented the policies that were considered criminal, that were atrocious by any measure. These individuals, according to Morgenthau, should be identified, first arrested, of course, and then identified to ensure that they are the people who the Allies believe they were. And then they should be lined up against a wall and shot by a firing squad consisting of shooters from the United Nations. He also believed that Germany should be deindustrialized. The term he used was pastoralized. Basically, Germany should be returned to an agricultural, pre-industrial stage of economy that would effectively prevent it then in the future from being able to wage war. So Morgenthau was concerned about the fact that Germany, arguably, certainly in World War I, certainly contributed to the outbreak of World War I. Many people at the time blamed Germany for World War I. And certainly in Europe, it's pretty obvious, I think, to most people. Maybe not to A.J.P. Taylor, a scholar who wrote a book on this topic, but to most people, it's pretty clear that Hitler was the cause and the Germans were the cause of World War II. So Morgenthau wanted to prevent another war from breaking out later. Thought the best way to do this was by deindustrializing Germany. Now, so far as we can tell, Morgenthau's view, which fit very nicely with Churchill, right? So the summary execution plan was very compatible with the way that that Churchill was thinking about how to deal with the Nazi war criminals once the war was over. Churchill and Roosevelt meet in Quebec. This is the second Quebec conference in September 1944. This is just a few weeks before Churchill met with Stalin in Moscow. And so in Quebec, Churchill and FDR talk about what they're going to do with the major war criminals, and they seem to have had a meeting of the minds at the time that they were not going to hold a trial of the major war criminals. Instead, they were going to execute them along the lines of both Morgenthau's and Lord John Simon's suggestions. So this is pretty late in the process, September 1944. But around the same time as this meeting in Quebec takes place, Henry Stimson, the Secretary of War, reads Morgenthau's plan, and Morgenthau had actually reduced his plan to writing and sent it to FDR, who seemed to agree with it to a large extent. Stimson catches wind of this and is horrified by it, so far as we can tell. And he decides that he's going to prepare his own memorandum to Franklin Roosevelt. We have copies of all of these documents now. They're widely available. In his memo to FDR in September of 1944, Stimson plants his feet firmly on the soil of holding an international trial of the major war criminals. He categorically refutes this idea of Morgenthau's that the major war criminals should be summarily executed. He rejects the Churchill plan, the Lord John Simon plan. And what he says is that if we go ahead and do this, first we'll be accused of victor's justice.
Yeah.
And second, if we move forward to deindustrialize Germany, we're going to cause mass starvation in Germany. And we're going to sow the seeds for future recrimination, for future revenge movements, much as happened after World War I. Hitler was able to make a lot of hay, as we all know, by dramatizing the Treaty of Versailles and fulminating against that and essentially blaming it for humiliating the Germans and grinding their face in military defeat. So Stimson said that in order to avoid this, a replay of what happened after World War I, we should have a true trial, an international tribunal consisting of judges and legal personnel from the victorious powers. And it should be a real trial. It shouldn't be a kangaroo court. You know, the Soviets backed an international trial as well. I mean, both Molotov and Stalin were advocates of an international proceeding of some kind. But their idea of that proceeding was very different from what Stimson was espousing. Stalin had in mind something akin to the show trials of the 1930s, where the guilt of the accused was a foregone conclusion, and it was simply a matter of holding a proceeding in which the government would simply demand of the defendant a declaration of their guilt, and of course they would have been worked over by the NKVD by that point, and tenderized to the point of just signing any document that was given to them attesting to their guilt. These are kangaroo courts, right? These are not genuine efforts with due process rights accorded to the defendant. These are courts held by Stalin and his cohorts to railroad people into convictions and to convict them and then to execute them. This is really what Stalin had in mind by an international proceeding. Stimson insisted that the international trial be a real one, that the major war criminals, and let's not forget that at this time, September 1944, Hitler was still alive. So they were thinking also of putting Hitler on trial. Hitler and Himmler and the rest of them would be given their day in court. They would have access to counsel, real counsel, who would defend them. They could examine the adverse evidence against them, adverse witnesses against them, and they should have the chance to have their case fairly heard by an impartial court, with the real possibility of an acquittal. And of course, Stimson also came out vehemently opposed to this idea of pastoralizing Germany. He thought that was a terrible idea. So on both fronts, on both counts, Stimson opposes the Morgenthau plan. That plan of Stimson's then begins to make its way not just through the War Department, but also through the Pentagon. And it won enormous support from one high-placed official after another. And eventually it found its way, of course, as a memo, it found its way to Franklin Roosevelt. Around the same time as Roosevelt read this memo from Stimson urging an international court, Churchill was meeting with Stalin, and Stalin was saying that under no circumstances would the Soviets agree to this idea of summary execution. So now we have two sources of influence that begin pushing or nudging Roosevelt in particular towards the trial concept. We have the Soviets, and then we also have Stimson within the War Department. I want to go back. We've been talking about events of 1944, fall of 1944. I want to go back a little bit to kind of fill in some of the details of what I think is the most important single moment in the kind of the lead up, the prelude to the Nuremberg war crimes trial, which was the Moscow Conference and the Moscow Declaration in October and November 1943. This is a conference that is held involving representatives of the Americans, the British, and the Soviets. It's pretty clear at this point that the Germans are done. It's not that they're not still dangerous; they're still a fighting force. Germany has yet to be, fully really invaded, and the Hitler government toppled. That's still a couple of years away. But Stalingrad is really over at this point. And at that point, in the winter of 1943, I think it was pretty clear to everybody that the Germans were done. It was simply a matter of time before the Allies defeated them. And so here we are, the fall of 1943. The Allies now need to start thinking about what they're going to do once the war is over. What are they going to have a war crimes trial policy in place? If they do, who is going to be prosecuted? Churchill was already advocating summary execution for Hitler and some of the other top Nazis. So these issues had to be sorted out, and they are to a certain degree addressed through the Moscow Conference. On November 1st, a declaration is issued by the conferees summarizing their policy, and they come up with a twofold program for dealing with Nazi war criminals after the war. So the first aspect of this policy was that they were going to extradite the lower-ranking Nazi war criminals. If they were arrested, if they were in Allied custody, they would be extradited to the countries in which they had committed their crimes for trial or whatever disposition those countries deemed to be fit for dealing with these lower-ranking Nazi officials. So that's one aspect of the Moscow policy now under the Moscow Declaration. We're going to send these lower-ranking people back through extradition to the countries in which they committed their crimes for prosecution by the now restored governments of these countries.
Just a quick question for you, Michael. We've covered on this channel Casablanca and Potsdam and Yalta. I mean, I'm not giving them in the right order there, but I can't help think that the timing of this was when the big players are still very much trying to work together. This is, the Stalin's seen Operation Torch happen. The Battle of the Atlantic is kind of not quite done and dusty, but it's moving ahead. The Second Front has been kind of promised. This is before they all start as leaders sort of throwing their teddies out of the pram and starting to think about the long-term future when you get the conferences a year and a half later. It seems really important that the timing of this, that it was at a good time for relations. Is that a fair comment?
Absolutely. Yeah. I mean, what we're seeing now are the Allies working together to develop a concerted, and that's the word maybe that is the perfect word for this context.
Yeah.
It's a concerted policy. Contrast this with World War I, which the Allies were also looking back at, where there was no concerted policy with how to deal with the Kaiser, for example. And it was a mess after the war. The Kaiser was able to get away to the Netherlands and escape retribution. The Allies wanted to put him on trial after the war. It would have been the first trial of a head of state for war crimes. And yet that didn't happen. And the whole program to hold German war criminals accountable for their atrocities completely collapsed after the war. So the Allies in World War II now are looking back at that and thinking to themselves, it's going to be very important for us to all be on board the same basic policy with how to deal with, in this case, with the Nazi war criminals. So I think your point is really well taken.
Thank you.
So now we have the evolution of a plan. There was a second aspect to the plan I think that's really important to emphasize here. We talked about the first aspect, which is extradition. The second component had to do with the major war criminals. The first component was with the lower ranking people. Second component is with the major war criminals, Hitler and Himmler and Kaltenbrunner and the Reich Security Main Office, and just a bevy of really top-ranking people, Bormann and so forth, and leaders within the German military. These are the major war criminals. The war criminals who, according to the Moscow Declaration, whose crimes had no geographical location. So you couldn't just pinpoint, for example, take Hitler as the supreme war criminal. You could not just point to a specific part on the map, a certain city, a certain locality, and say that is where the Führer's criminality was concentrated. It's not the case. His war crimes spanned the entire continent of Europe. And that was true also for Himmler and for some of these other top-ranking people. So these were the major war criminals, the ones whose offenses had no geographical location, but instead were expansive and were capacious. These individuals, the Moscow Declaration said, would be dealt with by a joint decision of the Allies later. They were not committing themselves to any specific policy. Now, in the decades after World War II, it was commonplace, and I've read it in one book after another, by authors who interpret the Moscow Declaration to mean that the Allies were setting up an international military tribunal to deal with the major war criminals, which is simply not true. Churchill, again, was still strongly leaning towards summary execution of the major war criminals. And the fact that they used this language of a joint decision to be made later by the governments of the Allies was ambiguous enough to allow for either summary execution or for an international military tribunal later on. And I think that's an important point to keep in mind. The decision had not yet been made. This is, November of 1943. Churchill was still very much wedded to the idea of summary execution. Morgenthau, even almost a year later, was still clinging to that same idea. FDR was waffling. He was initially in favor of summary execution, and we don't know exactly where he wound up. It looked like he was wavering, but his health was so bad in the last several months of his life that he was probably focused more upon that than on war crimes policies. It's interesting, too. We talk about ironies in Nuremberg. And this is another one, right? The influence of the Soviets, a country under Stalin which was a liberal, and legal officials within his government who similarly were involved in kangaroo courts that targeted the so-called enemies of the Soviet state during the 1930s. You have an illiberal government, a totalitarian government, which nonetheless prodded the other allies in the direction of an international court, and not only in the direction of an international court, but actually persuaded the allies to adopt certain doctrines of law that would become very fateful, very consequential in the history of Nuremberg. Now, one of these people was a Soviet jurist named A.N. Treinin, who was the chief of the Soviet Extraordinary State Commission for the Investigation of German War Crimes, and was a very prominent jurist in the Soviet Union. His key idea, his key contribution to Nuremberg was set forth in a book that he wrote that was then translated into English, and then parts of it were sent to the War Department, to the Pentagon, where they were translated into English and then circulated among key officials like Henry Stimson, like Murray Bernays, who I'll talk about here in just a moment, and then eventually, of course, by the Roosevelt administration. The key idea here that Treinin espoused that would influence Nuremberg was this idea of charging the Nazis with a conspiracy to commit crimes against peace. Now, Treinin was a very important official and a legal advisor to Wyszynski, who was the state prosecutor in Stalin's show trials in the 1930s. And Treinin provided a lot of of jurisprudence, of legal concepts that Wyszynski used in these trials against the alleged enemies of the state. Ideas like complicity, the idea of conspiracy. Conspiracy really is not a part of continental European law, or even really even of Soviet law per se, but they referred to it as complicity, which is tangentially related to conspiracy. So I'll use the term conspiracy because that's how the Americans and the British referred to it. So the idea was that, according to Creighton, that the Nazis could be tried in an international tribunal and charged with participating in a conspiracy to commit crimes against peace. That is, aggressive war, the crime of aggression, we would say today. And this idea, as I said, made the rounds within the War Department. It's going to go on to influence not only people like Henry Stimson and Murray Bernays at the Pentagon, but it's also going to deeply influence the direct individuals, the people who are directly involved in setting up Nuremberg. So people like Robert Jackson, we'll talk about him in just a moment. He was the chief of counsel for the American trial team at Nuremberg, a Supreme Court justice who was assigned to Nuremberg to head the American trial team. He was exposed to this concept through training of charging the Nazis with conspiracy to commit crimes against peace. So was D. Maxwell Fyfe, the chief of the British delegation at the London Conference, which created the charter that would serve as the foundation for the Nuremberg prosecution of the major war criminals. And then finally, Murray Bernays, whom I've referred to before, is the chief of the War Department Special Projects Section in the Pentagon, and would ultimately have an enormous influence on Nuremberg, because Bernays read the memo of Creighton, and he put that together with his own experiences. Before the war, he had been an SEC, that is a Securities and Exchange Commission lawyer, and a prosecutor in particular of corporate criminality. So he would prosecute corporations that were involved in violations of antitrust laws and of trying to restrain trade or being involved in anti-competitive behavior. And so he and his colleagues used the concept of conspiracy, an old English doctrine from the 12th century that begins to be used more and more in the 20th century in the United States, still used quite widely in American law and criminal law. So in his experience, he knew that you could use conspiracy as a way to get at actors within a complicated bureaucracy or within a complicated organization, right? And being able to tease out the specific contributions of every defendant can be very difficult. And this is one of the challenges that the prosecution team faced, certainly at Nuremberg and in the subsequent trials, because you have enormous organizations in some cases involving thousands and thousands of people. How do you document a specific act by one of the defendants that contributed to a war crime or a crime against humanity? And so under Bernays' influence, the Pentagon and ultimately then what will be the Truman administration, which succeeds Roosevelt, is going to be persuaded that conspiracy is the way to go. And we see here how Bernays' own experience in the SEC with the doctrine of conspiracy, along with his reading of A.N. Treinen, the Soviet jurist, influenced his thinking. And so he comes up with this idea that, yes, indeed, we should make conspiracy to wage aggressive warfare the foundation of the case against the major war criminals. Allied to this was the idea that we could go into court, into an international military tribunal, and invite the tribunal to identify certain Nazi organizations as being inherently criminal, that their very raison d'etre, right? The reason for existence was to commit atrocities, was to commit war crimes, violations of the law of war. And so this idea then of a criminal organization is advanced by Bernays, again, influenced by Treinen, also influenced by his own experiences prosecuting corporate criminality for the war. And of course, underlying all of this is the notion of collective liability. So if you demonstrate that somebody was a member of a certain criminal organization, then under certainly Anglo-American law, you can hold them accountable for the foreseeable consequences of the crimes committed by that organization. You can get at these figures, in other words, whose actual contributions might be a little bit hazy, might be a little bit vague. And this becomes a really important linchpin of the Allies' case against the major war criminals at Nuremberg, the notion of conspiracy by means of these criminal organizations to wage aggressive war on other countries. So this is yet another irony of Nuremberg, right? The illiberal Soviet Union pushes the Allies towards, first, an international trial, which neither Roosevelt nor Churchill were backing, at least at first. They nudge the Allies towards the idea of charging the major war criminals with aggressive warfare, and also nudge them towards using a very old doctrine of Anglo-American law, namely the doctrine of conspiracy. FDR, of course, eventually passes away. We don't know whether he ever truly abandoned the idea of summary execution and took up Stimson's trial idea instead. It's not really clear. One thing we do know is that his successor, Harry Truman, was an ardent champion of the trial concept. So he wastes no time at all. Just within weeks of being sworn in, he assigns Robert Jackson as the chief of counsel for the U.S. trial program, which would participate ultimately with the other allies in an international military tribunal trying the major war criminals. This idea of an international court then is raised at the San Francisco Conference in April and May of 1945. This is the conference that established the UN, but it's also the place where the U.S. delegation presented the trial idea to the Allies. The Soviets were already on board. They had been advocating an international trial for several years now. The French were on board. The British eventually come around, right? I actually have a quotation here from the British government on the slide. I'm not going to read it to you. Your listeners and viewers can read it for themselves. But essentially, Downing Street sends a message to Anthony Eden, who's representing the British at the San Francisco conference, and they tell him that yes, we will agree to an international tribunal. And I think that that Churchill gave this idea of summary execution up very reluctantly. I don't think he ever really came around to the idea, and I think he acceded to it as a way just to preserve unity among the Allies. So now, at this point, we're looking at June 1945. The next challenge which the Allies faced was to convert this plan to try the major war criminals into action, into law. And so a conference is held in London in the summer of 1945. It goes on for 2 or 3 months, and it will produce then eventually the London Charter on August 8th, 1945. This is the document that will be the charter, the legal foundation for the trial of the major war criminals. At Nuremberg, they had not yet decided on Nuremberg as the venue. I'll talk about that in a moment. But I'll just mention that the major charges against the defendants, we don't really have time to get into a detailed discussion of each one. I could spend an hour talking about each one of these charges. Don't have time for that. I'll just mention them, and maybe your viewers and listeners can look it up on their own. The London Charter is freely available online. You can easily find it. And just Google it or Chat GPT it. It'll come right up. So the charges were crimes against peace. There's the influence of Trainin and of Murray Bernays. Crimes against peace, war crimes, crimes against humanity, conspiracy. So in addition to the substantive charges that the major war criminals would face, they would also face a charge of conspiracy to commit crimes against peace, conspiracy to commit war crimes, conspiracy to commit crimes against humanity. And all of this would be done then by means of these criminal organizations like the SS, like the Gestapo, like the Security Service, There were 7 organizations altogether that the Allies wanted to have characterized as criminal, and they were going to submit a petition, really a motion, to the court to have it declare these 7 organizations to be criminal organizations. Ultimately, the court will only declare 4 of the 7 to be criminal. And I think they were the leadership of the Nazi Party was one criminal organization, the SD, the Security Service, the Gestapo, and the SS. Those are the 4 big ones. The Allies wanted to have the SA characterized as a criminal organization. The court refused to do it. They just didn't see it as a criminal organization, nor did it see the German General Staff as being a criminal organization. So now that they've hammered out the charges that would be leveled against the major war criminals, they had to come up with a venue. Now, keep in mind that the indictment, which is rendered in October of 1945, was done in Berlin. It wasn't done in Nuremberg, it was done in Berlin. So now the Allies had to decide where to hold the trial. And I think there's a lot of misunderstanding about the thought process here. I mean, ultimately, the Allies are going to choose Nuremberg as the site for the trial. To this day, and when I teach this course for law students, a course on the Holocaust and law, I'll ask the students, why was Nuremberg chosen? And the students rarely get the correct answer, interestingly enough. They all come back to the idea that Nuremberg was a symbol, right? It was a symbol of the Nazis. It was what the Nazis called a Führerstadt. There were certain cities in Germany that had associations with the Nazis, and certainly Munich was one of them, right? But Nuremberg was too. It's where they had their party rallies every year. It's where the Nuremberg laws were decreed in 1935. September of 35, the Nuremberg laws are announced there by Hitler. A very important figure, Julio Streicher, the publisher of Stürmer magazine, probably the most powerful and pornographic and awful anti-Semitic screed published by the Nazis and by their anti-Semitic government. Streicher was the Gauleiter of Franconia, which is the area in which Nuremberg was located. So a lot of people think that there was like a symbolism involved in sending a message that we're going to hold this punishment of the Nazis in a Führer city where the rallies had been held. And I don't want to discount that and say that it played no factor. I mean, there might have been, like on the fringes, maybe the Allies were thinking about that a little bit too. But there was a really good reason why Nuremberg was chosen. It was chosen because, number one, it was in the American zone.
Yep.
It was really important for the Americans to have the case tried in the American zone for reasons of command and control. And it had a fully functioning, intact courthouse.
Yeah.
And not only a courthouse, but it had a prison attached to the courthouse where the major war criminals could be kept and then brought directly down a corridor into an elevator up to the 6th floor of the Palace of Justice and brought, get this, directly, the elevator doors open and you're right inside the courtroom 600. It was the perfect arrangement for what the Allies wanted to do. I really think it was pragmatics more than anything that led to the choice of Nuremberg. So Nuremberg is chosen as the site. Now, of course, the Allies have to decide who they were going to prosecute. The British had a list of people they wanted to arrest from pretty early on, already 1943. And the list was in existence. The Americans had a list too, so that after D-Day, as they began to close the ring, as Churchill calls it in his memoir of the war, closing the ring on Berlin, right? They have these lists of people that they want to arrest. So the British have a list, and the Americans have a list. The British have really base their list on the notion of symbolic value. Which Nazis were associated in the British mind with the crimes, the atrocities committed by Hitler's government. For the Americans, again, they're working more from, especially by 1945, they're working more from a paradigm of corporate liability, going back to Bernays and this idea that we're going to use conspiracy and membership in criminal organizations that are devoted to committing crimes against humanity and crimes against peace and war crimes. That's going to be our ideological foundation, the legal foundation for how we choose people for this list. And so, as they close the ring on the Nazi leadership, certain officials fall into the hands of both the Americans and the British. And the Americans consult their list, and sure enough, they have the custody over people like Robert Lai, who was the head of the German Labor Front, Ernst Kaltenbrunner, who succeeded Heydrich as the head of the Reich Security Main Office, Goering, of course, head of the 4-year plan, chief of the Luftwaffe, a very important figure, second only in power to Hitler. He would have been Hitler's successor at one point, and Hitler died earlier in the war. I could go on and on. You can see the names for yourself. Wilhelm Frick, the head of the Reich Ministry of the Interior, and so forth. These are all figures whom the Americans thought participated in war crimes, crimes against peace, and crimes against humanity, and did so at a very high level in terms of policy making.
Was this the Crocas list?
Come again?
Was this the Crocas list?
I think it was related to the Crocas list.
Because it was interesting when we had Guy Walters on Monday, and he interviewed a couple of, I forget the guy he interviewed was Gerald something or other, by the British, the head of the British War Crimes Investigation Unit.
Yeah.
And he interviewed him like 60 years after. He'd never seen the list.
Really?
It was interesting. We were postulating exactly how far this list went. If the main guy investigating hadn't ever seen a copy of it, it just there's questions raised. That was the
there's so much other history that we could talk about. I just don't think we have time. I could talk about the UNWCC, the UN War Crimes Commission, which actually provided a lot of information to both the British and the Americans on Nazi crimes that were being committed. But in the interest of time, the British, Rudolf Hess, of course, deputy Arthur Seyss-Inquart, who was he was the governor of the Netherlands, involved in deportations of Jews to their deaths. Karl Dönitz, I'll talk about Dönitz here in a minute. Alfred Jodl, the chief of staff. Speer, the architect, head of the mobilization efforts in the last few months of the war, and then Joachim von Ribbentrop, who was the foreign minister. We're all in British custody. So these individuals are all arrested, and they are then detained. And the British ran a detention center. It was called Camp Dustbin, not too far from Frankfurt. You probably talked about this maybe in some of your other podcasts. So I don't want to spend too much time in covering ground you've already covered. Camp Ashcan, of course, was the American facility, and in Luxembourg, you can see this photograph. I love this photograph. It's called informally the Class of 45. This consists of the major war criminals who were detained at Camp Ashcan. You can see in the middle the pudgy figure of Hermann Goering before he lost all of his weight, awaiting trial. But there he is in the middle of it all. The French and the Soviets had far fewer of the top war criminals. The Soviets had a propagandist who worked for Goebbels. Keep in mind, Goebbels had committed suicide. I think his wife also committed suicide, and they murdered their entire family. And all six, it's a horrible story. But so he was no longer available for prosecution, but one of his underlings, Hans Fritzsche, was. And so the Soviets insisted that he be put on trial. Erich Raeder, former admiral, was later replaced by Dönitz, was also in Soviet captivity. The French had Constantin von Neurath, who was the predecessor as foreign minister to Ribbentrop. The indictment itself was issued in early October 1945. It recited the same offenses, the same crimes that we've already talked about that appear in the London Charter: war crimes, crimes against humanity, crimes against peace, conspiracy, criminal organizations are the major ones. And you can see this very famous photograph of some of the defendants in the dock at Nuremberg. It might be helpful to talk a little bit about some of the challenges legal challenges in particular, that faced the International Military Tribunal, and that have continued to a certain extent to dog these trials. I mean, even today, I hear people raising these points. It's remarkable. The criticisms arose already in the 1940s from various quarters, and you still hear these criticisms today. So maybe we can talk a little bit about some of these challenges that the court faced. One of the big ones, of course, was the argument that these trials were ex post facto. This is a phrase that we use in the United States. It's in our Constitution. The federal government cannot pass ex post facto laws. These are laws that criminalize behavior that was not criminal at the time that the actions were carried out. In Europe, I think it's called the ban on retroactive law or something to that effect. Retroactivity is banned by the principles of justice, as they're called. And this has been a criticism of the trials almost from day one, and continue to sort of linger over the trials, and people can make up their own minds as to what they think. There might be a nucleus of truth in that, but ultimately you have to decide: is it better to be a stickler for retroactivity and not trying people for retroactive laws? Is it better to preserve that as a principle, or is it better to punish completely unimaginable atrocities that nobody could have foreseen, and that cry out for justice? What's the better plan? And I happen to incline towards the latter. I think that retroactivity is an interest that we want to protect and preserve, but sometimes there are circumstances in which there's a higher legal good to be pursued. And I think justice is a higher legal good here. But at any rate, people can make up their own minds as to what they think. Disagreements in recent decades have broken out among scholars about this idea of the conspiracy charge and the centrality of the conspiracy charge. And this goes back, I think, to the years after 1945, when most of the history that was written about Nuremberg was written by participants. It was written by judges, like Francis Biddle, for example, the American judge.
Yep.
It was written by Telford Taylor. Forgive me, I'm getting a telephone call. I'll cancel that.
Someone telling you're on World War II TV, probably.
What are you doing? You made a misstatement about this or that. What are you doing, you jerk? No, there's been a reevaluation of the way in which this history is portrayed. So many of the early commentators who sort of formed the premises in the public perception of Nuremberg were participants, and they were not just participants; they were Western participants. So American British participants in particular, who kind of set the seal for how the trials were seen. And so there's a lot of emphasis upon things that the Americans did. The Americans thought of the trials as being the product of American idealism and of American commitment to the rule of law. And maybe the British, participated in that as well, but not to the extent that the Americans did. And the Soviets, of course, were portrayed as being truculent, as being resistant to the rule of law, as demonstrated at Nuremberg. They were all portrayed as being thorns in the flesh of the other allies. So this was the narrative to a large extent. There was a movie that came out in the early 1960s, Justice at Nuremberg. It follows this kind of the idea of the crusading Americans and leading the West forward on this path to greater freedom and for all people. A very idealistic sort of self-glorifying image. And I'm not saying it's totally without some amount of truth. The Americans were very important in pushing the trials ahead. But recent scholarship has come out and really challenged this, suggesting that yes, the Americans are important, but so were other parties, whether it's the British or the French, but especially the Soviets. And I'm thinking of two scholars in particular, Francine Hirsch and George Ginsburg, in the past several decades, who have really tried to valorize, for the first time, the Soviet participation in Nuremberg. They weren't just obstacles to justice. They weren't just pains in the neck for the other allies, but they made genuine contributions to the judicature, to the law, to this legal framework that informed the trials. So this is another aspect of the history of representations of Nuremberg, which I think have changed the debate to a certain extent, and how people today will see the trials. There were already challenges that broke out early on, even before the IMT was convened. The Americans contested the claim by the Soviets that the Baltic countries belonged to them, that they were legally acquired by the Soviets in 1940. The Americans thought that the Baltic countries had been basically invaded illegally, much as Poland had been invaded. So the Americans were concerned that if they signed the indictment, that this would be tacit recognition by the Americans for diplomatic purposes that the Baltic countries belonged to the Soviet Union. So there was some wordsmithing that had to be done and some feathers that had to be unruffled in order to work that out, and it was worked out. One of the most interesting contentions, certainly for me, and I think for a lot of other people too, who study the post-war legal confrontation with Nazi crimes, was the brass-knuckled sort of fight over the Katyn Forest massacre.
Mm-hmm.
I don't know if this is something, Paul, that maybe you've talked about with some other people and other podcasts or in other interviews you've done for the podcast. So I don't know how much time to spend on this, but basically you had over 20,000 Polish military officers and policemen and members of the intelligentsia who were shot in the forest, a forested area called the Katyn Forest in Western Russia. And that shooting was, we know now, carried out by the NKVD. Even Vladimir Putin has said that the NKVD carried the shooting out. And don't forget that as a part of the Ribbentrop-Molotov Pact, the Soviets moved into their sphere of influence, the Germans moved into theirs. So in doing this, then they encountered this Poles, and much like the Germans, they were trying to get rid of the leadership class of Polish society and their part of their sphere of influence. And so they murder over 20,000 of these Polish, these unfortunate Polish nationals. But the Soviets were hell-bent on blaming the Germans for this atrocity. It's one of the great mysteries to me, one of the great mysteries of World War II. Why did Stalin, and this is being called, the shots are being called from Moscow.
Mm.
Stalin and his people are sending direct messages to Rudenko, the Soviet prosecutor, and even to the Soviet judge, that they are to really bear down on this and see to it that the Nazis are convicted of the Katyn Forest massacre. Well, the Americans and the British had done their own legwork, and they were pretty certain that the Germans did not commit. They did a lot of, obviously, a lot of atrocities in Eastern Europe, but this one they were not responsible for. And the Germans said the same thing. They said, we were involved in a lot of deviltry during the war, but this is one you can't blame on us.
It's that weird thing, like when a serial killer has admitted to 7, but saying, that one wasn't me, though. That's not my style. Yeah, that weird dynamic. Yeah.
Yeah. And of course, we're talking about macro criminality here, as opposed to like a serial killer. We're talking about a government. I'm not sure why they pressed the issue so vigorously, but they did. And ultimately, the Americans and the British said, we're going to have nothing to do with this charge. If you want to argue it, you argue it. And of course, the charge was just dismissed because there was no evidence for it. It was amazing. I could get into the weeds of this, and I'm so tempted to do so, but it would prevent us from moving forward. But the Soviets did a sham investigation conducted by a guy named Burdenko. He was a jurist who was put in charge of this investigation, and he prepared a report which is completely spurious, right? Just filled with all kinds of sham information, false information. And then the Soviets tried to use that as a basis for prosecuting the Germans at Nuremberg. There's no way. Again, this is not a kangaroo court. The judges were not going to admit that report. It was hearsay, for one thing, and it was larded with lies and misrepresentations. So the Soviet case crumpled very quickly in that regard. This guy that we see on the screen right now is, of course, Karl Dönitz, head of the U-boat fleet, eventually the admiral of the German Navy. I mentioned Dönitz here very, very quickly, kind of in passing, because he represents an exception at Nuremberg. Now, the Allies that tried to adopt a type of procedure, a criminal procedure that would blend together these two disparate legal systems that are represented at Nuremberg. So you have the Anglo-American system, we call it common law system of law, based upon principles of due process and the notion that you have a prosecutor and a defense counsel. The prosecutor has to prove the case. The defendant is presumed to be innocent until the burden of proof is shifted back by the prosecutor to the defendant, who then has the responsibility, if he wants to avoid being convicted, to defend himself or herself. So this is the Anglo-American system, but of course there's the civil law system too, which is typical of Western Europe, and to a certain extent today, certainly of Eastern Europe too, and of Southern Europe. And the civil law system was typical of Germany. Germany is an example par excellence of the civil law system, which is much more committed to a judge-centered sort of trial. And even though there are convergences in some regards between the two systems, there are lots of differences too. And I won't talk about those differences. It's too far into the weeds, I think, right now. Instead, I want to talk about one really important aspect of criminal procedure, that Dönitz was actually able to circumvent in his defense.
Mm.
And that has to do with the so-called tu quoque defense. The tu quoque, again, this is a Roman law concept.
Yep.
What it means is the U2 defense. It's about a very powerful defense if you can make it. And that's true today too, by the way. As a former criminal defense attorney, I try every so often to try to use it. It's tough to get it into court because technically it's irrelevant, right? What the prosecutor and the government did shouldn't really matter that much. Ultimately it's what the defendant did. Did the defendant break the law? And if so, then the defendant should be found guilty. So the tu quoque defense was arguably barred by various articles of the London Charter. But Dönitz had a very enterprising lawyer representing him, a man named Otto von Kronspühler. Kronspühler was able to secure an interrogatory from Chester Nimitz, the head of the American Pacific Fleet, which said, in essence, that the Americans followed the same strategies in the Pacific that the German U-boat program did in the North Atlantic. And you can imagine how powerful an interrogatory this would be, because it essentially says that Dönitz did the same thing that the Americans were doing. The Americans didn't regard themselves as committing war crimes. Technically, this should be banned under tu quoque. Kronspühler should not have been able to offer that interrogatory into evidence, but the judges accepted it. And who knows, it may have saved Dönitz from being hanged. We don't know, because he was never convicted for certain aspects of the U-boat program that were really incriminating, bombing hospital ships, bombing merchant vessels, and so forth, failing to provide sustenance for sailors whose boats had been torpedoed by the U-boats. So the Americans essentially said that we followed more or less the same sort of strategy. That makes it to the judges. The American judge in particular said he refused to convict Dönitz based upon this interrogatory. If the Americans were doing it, then we shouldn't expect the Germans to be convicted for more or less the same kind of behavior. He was convicted for other war crimes, by the way, but not on that particular count having to do with the U-boat program. The verdict was handed down on October 1st, 1945. Keep in mind that there were only 21 defendants of the 24 who had been indicted. Only 21 were in the courtroom for various reasons. Martin Bormann was probably killed in the waning phases of the war. They did not know that at the time, and so they indicted him in absentia and tried him in absentia. He was convicted and sentenced to death, but he never appeared in the courtroom. A couple of other guys, too, were not there for various reasons. So really, there were only 21 defendants who were present. 12 death sentences out of this number, out of the 24, 12 death sentences, but there were 3 acquittals. And as I tell my students, the fact that there were any acquittals, I think, is pretty strong evidence that this was not just a kangaroo court. As I said a little while ago, kangaroo courts have 100% convictions and 100% maximum punishment. Right? People are railroaded into these outcomes. They don't envision acquittals. And yet you do have 3 individuals who were acquitted during the case. Now, I'd like to sort of move towards wrapping up my presentation. We're coming up on an hour. So I want to talk a little bit about the so-called subsequent trials at Nuremberg, and then maybe talk about some of the questions that our viewers and listeners might have. The Americans were not done once the International Military Tribunal was over in October 1946. Now, Robert Jackson was done. Robert Jackson was the head of the trial program. He leaves, he goes back to the Supreme Court, but he is now relieved by Telford Taylor, who's a brigadier general at this point, and he succeeds Taylor as the head of the American program for another round of trials that now will be tried entirely by the United States. So this next round of trials do not also involve the British or the Soviets or the French. They're done entirely by the Americans. And they're called the subsequent trials at Nuremberg. They take place between October 1946 and April of 1949. And they're not based so much on the London Charter. Instead, they were based on a separate document called Control Council Law Number 10, which was issued in December of 1945 and provided for trials that would be held by each of the four victorious powers in their zones of occupation. So the French would have their set of Control Council Law Number 10 trials that would be administered only by the French authorities. The British would have theirs, although the British didn't really use Control Council Law Number 10. They used the Royal Warrant instead. They had their Royal Warrant trials. So they never really used Control Council Law Number 10, hardly at all. The Americans, of course, conducted all of their trials other than the military commission trials, which were held by the American Army. They held all of their other trials under the auspices of Control Council Law Number 10. And then the Soviets, in their zone of occupation, were entrusted with the discretion to create courts under Control Council Law Number 10 to prosecute Nazi war criminals in their zone of occupation. Ultimately, there were 12 trials that the Americans tackled, some 185 defendants. These are really blockbuster cases, and we don't have time to get into them. They're fascinating cases. When I teach an entire course on the Holocaust and law, I go into quite a bit of depth, looking at the doctor's trial, for example. It was an entire trial devoted to medical crimes committed during the war, especially in concentration camps, where so many of the grisly, really just macabre experiments were carried out by Nazi doctors and Nazi scientists. There was an entire case devoted to the complicity of judges and Nazi prosecutors and railroading people into phony convictions and executing them. And, all kinds of crimes, war crimes, crimes against peace charged against Nazi jurists. There was an Einsatzgruppen trial that was held, a ministry's case dealing with the Foreign Office, and so forth. Right? There were 12 of these cases that were really centered upon professional groups. That was Telford Taylor's recipe for putting together a list of people to be prosecuted by the Americans in the subsequent trials. He wanted to look at professional groups, doctors and lawyers. He wanted to look at policemen, so members of the SS, and members of various SS organizations, including the Reich Security Main Office and the Einsatzgruppen, again, cops, right, predominantly police, ministry officials like the Foreign Office. So the message that Taylor was trying to send, he's very, very explicit about this in his communications with the government during the trials. He said that we're trying to send a message. We want the Germans to understand that it wasn't just Hitler and his henchmen, that these crimes were being carried out at all levels of German society, and they involved German elites, and not just elites directly connected to Hitler, but also professional elites, members of the medical profession, members of the legal profession, policemen in Germany, and so forth and so on. And again, a fairly successful series of trials. Most of the defendants were convicted, and yet we also have acquittals. And I think you probably talked about some of the acquittals at the Farben case.
Yeah.
This is another example. So these are industrialists, financiers and industrialists, a professional group of people who were involved in backing Hitler and enabling him to commit his crimes. So Taylor wanted to send that shot over the bows to alert the Germans that this was a societal-wide criminal enterprise. And the fact that you had acquittals, to me, I mean, many people lament those acquittals as being failures of justice. I look upon it as being a vindication that these were real courts and not just victor's justice or kangaroo courts, as critics of Nuremberg have claimed. So I think I probably have talked enough at this point. According to my watch, I'm a little after 2 o'clock. It's been about an hour. Why don't we turn it over to any questions that people might have?
Well, firstly, thank you very much, Michael, for walking us through this. It's been really enlightening. So but you did it too, reference you made earlier on. I mean, the thing is, did anybody kind of learn from that in these ensuing trials? Because I mean, I'm thinking about even 40 years later, the Klaus Barbie trial, because the defense, Jacques Verge, used that in that courtroom in Lyon 40 years later. Yeah, but everybody else was doing stuff. It wasn't just, so was there any attempt to find a way of dealing with that as a plea by defendants?
Yeah. Now, at the successor trials, that informal rule continued. Right? And again, it's not explicitly stated, going back to the London Charter. It's teased out of the London Charter. And the idea that the last thing the Allies wanted was for the Nazi defendants and their counsel to put the Allies on trial. Now, as a former criminal defender, I can tell you, there is no more powerful defense. Maybe there are a few that are as powerful, but certainly that is an enormously potent defense. If you can get the jury, let's imagine there were no juries, of course.
Yeah, of course.
So these are judges. It's much harder to, quite frankly, to pull the wool over the eyes of the judges, right? It's much easier to get a jury to sympathize with your defendant. Your defendant could be as guilty as sin, but if you can get the jury to focus on the misdeeds of the prosecutor, the misdeeds of the government, then a lot of well-intended people, intelligent people, will say, that doesn't sound very just to me. I mean, this guy is being prosecuted for something that the government that is prosecuting him is also doing or has done, and oftentimes in that situation, an acquittal will arise. The Allies understood that, and so they construed the language of the London Charter to bar tu quoque. Now, what do we say about Kronzbühler? And Kronzbühler was able to get the interrogatory. He got it in. And to this day, I'm not entirely sure why he was able to overcome the bar on tu quoque, because other defendants weren't able to do so. There was discussion of Dresden, the bombing of Dresden. There was discussion of Hiroshima. Look at what the Allies have done. Look at what the Americans did at Hiroshima. Why aren't American policymakers being hauled in front of a court, right? And the Allies just wanted to prevent any of that language from coming in. Now, you have judges rather than juries, right? If there had been jurors there, then, oh my goodness, you can imagine what effect that would have had. I'm not sure how much of an effect it would have had on the judges themselves if they had heard the testimony about Hiroshima. They understood that ultimately it's not relevant. Because the Allies were not named as defendants by the indictment. It was Ribbentrop and Goering and the rest of them who were sitting there in the dock. It wasn't Harry Truman, and it wasn't Winston Churchill. So really, it was irrelevant. All this other background stuff was irrelevant. But that bar on tu quoque continued, at least informally, through the successor trials. And then the judges try to keep it out as much as they can. Again, if you can get it in, it is extremely powerful, at least potentially. It could be a stick of dynamite. But technically, it's even today in American law, it's technically not allowed.
Okay, thank you.
We've got. You can blurt it out. There's an old saying: you can't unring the bell. You can't unring the bell. So, so suppose you blurt it out, and the judge reprimands you. You say, "Oh, I'm terribly sorry." The judge
you've sown the seed. Yeah.
You can't unring the bell. I typically didn't do that too often, but every so often, it's easier to say, "Oh, Your Honor, I'm terribly sorry. I understand that's not really allowed. So let's just strike it from the record. Just strike that from." Well, the jury has already heard it, right? But,
thank you. So Trevor is asking, were there any appeals? What was the appeals process? Because as a limey as I am, when I look at, for example, the USA and people on death row, it's like, oh, another appeal, another, how many times can they, ask everybody to reconsider it again? But it doesn't seem to come up very much in discussions about Nuremberg.
Yeah, technically they could pursue an appeal to Lucius. Initially, it was Lucius Clay, who was the head of the Allied Control Council and the military governor, certainly in Bavaria, for the successor trials. For IMT, it would have been the Allied High Commissioner. And with the American trials, in theory, you could pursue an appeal even further, all the way to Washington. And there were a few efforts to do that. Actually, there was a Yamashita, in the Yamashita case in Tokyo.
We're hoping to do an entire show on the Yamashita case at some point in the future, so because it's really, really important.
It's really important, and it's important jurisprudentially, like legally, in terms of the precedents that it created. It's really important. But poor Yamashita, probably should not have been convicted. But he pursued, his appeals, and they went nowhere. I think Karl Brandt, who was the poster child for the medical case in the successor trials, I'm pretty sure that he pursued an appeal also. But again, they went nowhere. And It's only later on that the Allied High Commissioner was going to adopt a clemency program. In 1951, John J. McCloy was the Allied High Commissioner, and he actually was persuaded by the Germans in particular, working with the Americans, that it's time to let a lot of these people out of jail, out of prison. And so there's an amnesty program. That's not really an appeal so much as just a way, sort of back deal or back door to let people out of prison and relent on their punishment.
Well, thank you. And the last question, although it's potentially a bit of a rabbit hole from Andreas, is that can Michael speak about the influence of Nuremberg on the Tokyo trials and the differences? Because we had Adam Wakening on from Australia earlier this week who was saying that the trials out that they did try and run them in parallel with cross-referencing the protocols, things like that. And well, there's the question.
Yeah, no, it's an excellent question. And the answer is yes. I mean, there's clear cross-pollination. I mean, so far as I know, the framers of the Tokyo Charter just cribbed almost word for word the language of the London Charter and the indictment as well. So that the crimes are virtually identical. Crimes against peace, war crimes, crimes against humanity. I believe they're the conspiracy charge and criminal. I don't know about the criminal organizations. I'd have to look at the Tokyo Charter to see if they had a criminal organizations. I'm not sure that they did. But certainly the other charges, including conspiracy, were built into the Tokyo Charter, and that comes directly from the London Charter and the Nuremberg jurisprudence.
Well, I think as much as I'd like to carry on talking to you, I mean, we will bring this to an end. But I always like the fact that when something enters language, it's because it's significant. And for me, I think one of the recurring themes of these discussions is that the Nuremberg defense is something people will use. Like when even today, a newspaper will say it's D-Day for the Formula One racing team coming up. It's one of those fallback phrases there. And Guy Walters kicked it off on Monday with this, this sense of I was only following orders. Now, complicated that is, and he made the big point that in his research that he could find very, very basically no cases of any German officials, soldiers, officers ever really being punished for not doing anything. And yet that was, it's part of our language that they could go on there in the dock in the various trials and say, I was just following orders. If I hadn't done what I'd done, I'd have been punished. What's your take on that?
Yeah, could I just build on that a little bit? According to the London Charter, superior orders was ruled out as a defense.
Yeah.
You could not raise it. Now, what you could do is if you were convicted, then you go to the sentencing phase. There basically are two different phases of trial. You have the findings phase where either the judge or the jury finds what the facts are, and then they apply the facts to the law to generate either a conviction or an acquittal. So the person's found either guilty or not guilty. Then you go to the sentencing phase, and that's where the court determines what an appropriate punishment should be. So according to the charter, at that point, you could raise a superior orders defense. You could say, look, I was just a loyal soldier, footman, doing what I was told to do. Okay, you found that I violated the law. Maybe that's true, but I didn't go over and above my orders. I did what I was told to do. And judges or in some cases juries might take that into account as a factor in mitigation, so the person might have a reduced sentence because of that. I think of Speer, and his ability to avoid a lot of the implications of what he was doing. There's a lot of mitigation that was given to these defendants, including at the successor trial, and you had the Farben trial on justification. A lot of mitigation given, and in part because they tried to make a duress argument, or they were doing things that were a part of their orders, and sometimes the court looked favorably on that, especially in the sentencing phase.
Well, it comes back to my original point and of how complicated the whole thing was. I mean, the scale, the volume, the breadth and depth of all these atrocities, and no wonder that the legal precedents weren't quite perfect to deal with it. It would have been a miracle if they had been. It had to evolve, and we can still argue. I mean, it's your field, not mine, that it's still evolving. This whole idea of responsibility and crimes against humanity, and at what point is this person responsible for something that's part of a wider set of whatever we define crimes as. I think we can all kind of deal with that this is a guy who shot his wife in the face with a 12-bore shotgun. That kind of, we can kind of take on that simplicity of that. But this is it's the layers of this that are so complicated. Where does responsibility begin and end? And how do you quantify that? How do you process that and establish that? And I think that's where I am so far on with this series, just how complicated the whole thing was.
Enormously complicated. And think of the time period too, Paul. I mean, the war comes to an end, May, at least in Europe. It comes in the Pacific, it's in August. But nonetheless, in Europe, it's in May 1945. Just a few months later, they're prosecuting the major war criminals in Nuremberg.
Yeah.
I mean, that's an extraordinary thing. Yeah. I mean, it's mind-boggling that they were able to pull this together with 4 different countries, trying to somehow combine their very disparate, very different sorts of legal systems together so that each country felt that their quest for justice was represented at Nuremberg. Yeah. And then you had these complicating factors, like the fact that the Soviets also invaded Poland.
Yeah.
And the Soviets perpetrated the Katyn Forest massacre, which they were insisting on charging against the Germans. And the Soviets were outraged at the Americans and the British because they wanted to have nothing to do with the Katyn Forest massacre. And then the judges allowed the German Defense Council to put on a case that essentially said tu quoque, we didn't do it, you did it. And the Soviets said, listen, they shouldn't be allowed to do that. They should not be allowed to claim that we committed the Katyn Forest massacre.
Yeah.
Based on the tu quoque principle. And so, my God, it's when you think of the complications sewn into this process, and they were able to pull this off just 6 months after
in the middle of millions of people moving around via deep displacement camps. Britain's got a new government. The US has got a new president. France is beginning to establish its new republic. Most of Europe is in ruins. The Cold War is brewing. Public opinion is, we've had enough of the war. Can we just go home and have Coca-Cola and watch the football and not talk about this? And at the same time, create a new legal system to deal with this. I mean, it's a miracle anything got achieved in some ways. When you think of that,
this is why what they did was path breaking. We still refer to the Nuremberg principles. I mean, so much of international law, international humanitarian law, as it's called, like the ICC and the Rome Statute, it's based on the London Charter. It's based on what happened at Nuremberg. So not only did they do it really quickly, they did it in a way that is simply masterful. And it's again, I'm not a fanboy when it comes to this sort of stuff. I just look at it pretty objectively. It's quite
no. I mean, it's why we're continuing to look at the months and years after 1945, because the war may have come to an end, but the troubles, tribulations, and issues were only beginning. So, well, we'll leave it there, Michael. I'm off for the weekend, folks. And next week we're going away from war crimes for a bit. Some few infantry presentations. We've got Guadalcanal, we've got Saipan, we've got the British at Dunkirk in 1940 in a rear guard action by the 12th Lancers. And then the week after, we're back to war crimes. I think I'm doing 9 shows. It might be 10 that week. So no rest for the wicked that week. But in the meantime, thank everybody for your fantastic comments. Buy my guest books, read their blogs, check them out, and keep coming back to World War II TV. So thank you, Michael. Have a great weekend, everybody. Cheers.
Take care. Bye-bye.
Bye.